Well, I don't think they should have a right to do so. It's the fact that people are saying we should because it's online. As I pointed out with the case in Germany of the man who basically told Wikipedia, this 13-year-old case that I killed somebody, you need to take it down. I mean, and depending on what you consider an archive, how broadly you consider that, it's already happening. Maybe not in the US. And another thing is, when you think about paper, people don't want to deal with paper. So most people are not gonna, I mean, there are a few of us, and obviously, you know, law students and then lawyers, you deal with paper all the time. You have, and sometimes you like it a little bit. But most of us are not gonna, you know, go to a library or an archive or whatever memory institution is and sit and sift through all this information about you. But online, it's easy to sift out and find that needle in the haystack about people. And I think that's one of the big issues, is that it's easier to find out that dirt on someone than it is going to the library or the archive and finding that information. And I think that scares people a lot as well. Also, people are putting a lot more information out on the internet than you would find in a paper archive. You know, your party photos, your things that you generally wouldn't see elsewhere are out there and available. And even when you think you've deleted them, they're not deleted. They're somewhere on the internet, and people don't want people to find that anymore. That's the issue, or one of them.
I just wanted to, it's interesting how we can, it's interesting how we have no problem protecting this right to be forgotten with regard to property in order to enhance property values, because you certainly find it in the area of property which has been the location of an infamous crime scene, that across the country, states have no problems changing addresses, changing plat mats in order to hide the fact that a location was an infamous, bloody, whatever crime scene in order to enhance property value. So in some sense, that right to be forgotten is perfectly acceptable when it comes to enhancing property values, and it would seem that it should be acceptable to enhance a person's value going forward.
Well, it really depends on how you conceptualize property. I mean, privacy, I should say. If you conceptualize privacy as a property right, then you may not have a problem with the right to be forgotten. So if you say, any information about me I own, no matter who's in possession of that, then I can assert the right to people delete my information because I own it. But here, it's not really the control of information that matters. It's kind of the possession of information that matters.
Over the summer, I was privileged to work at a public defender's office. One type of research that we did was for voir dire, for potential jurors. We would go on Facebook and other data collection sites to see what kind of people they were and who we should choose to be our best bets for our client. What do you think about this kind of research? And if that research is valid, should we archive it for future use?
Oh, okay. So the question was about researching on the internet, specifically on social media sites, to find out what kind of people are for juries, etc. And what do we think of this, and should it be archived for the future? I sort of think that you know, once it's out there, it's out there. I guess there's a point beyond which you can't put the genie in the bottle, back in the bottle, and so so my argument would be, off the top of my head, why not archive? Why not let us know in the future something about what we thought and felt in 2012?
And just to be clear, that type of research if it wasn't clear before, is not the type of research that is regulated under 45 CFR 46. So one of the things that I didn't discuss is actually that research is defined in that set of regulations. And research is a systematic investigation designed to contribute to generalizable knowledge. And so that type of research is usually academic research. We have a rule of thumb where if a researcher is going to present the information or publish the information in order to make a contribution to typically an academic field, that is research, and then if it involves human subjects, it's regulated under 45 CFR 46. So just to be clear that there's no expectations that IRBs are going to have any kind of oversight over that type of work specifically.
And I will say people are looking into how to archive social media. And I mean, in the past, we would archive personal material through journals that were left behind. And now we're looking at these as journals and a way to document, it's a way to document life during our times. So there are people who specialize just in digital archives and preserving that information. So, yes.
My question is about the right to be forgotten. I think this is the first time I'm hearing about this right to be forgotten, and it's pretty interesting for me. But what I'm wondering is, I don't know about the jurisprudence and the constitutional law in the US, but in India, under the right to freedom of speech and expression, we also have the right to not express. We have the right to be silent, right? So if you're looking to protect the right to be forgotten, why not look at using the right to freedom of speech and expression as a tool to protect the right to be forgotten, rather than looking at privacy, which is obviously going to be very different?
So the question was, why not use freedom of expression as a foundation for protecting the right to be forgotten? Certainly, under the First Amendment, you do have a right not to speak, a right to not speak, and a right not to be compelled to speak at all. I think one of the problems with using that as a foundation would be we're not infringing on your right to express yourself. The right to be forgotten would be infringing on the right of somebody else to talk about you or to find out information about you. And there, I think, lies the problem. So you certainly have a right not to express yourself, but when you do, then someone can talk about how you expressed yourself, or people can observe or find out about you and express what information is out there and available. I think that perhaps would be an issue with using First Amendment right not to be compelled to speak as a foundation for the right to be forgotten.
This is a question about the common rule. So my understanding is that it essentially applies to federally funded research. Yet when you have groups like patients like me and or data mining companies or pharmaceutical companies conducting the type of research we talk about, it's not necessarily federally funded. And so I know there's been some discussion about having the common rule broadened to apply as a statute, a general regulation to all research. But can you comment on where that's going?
Sure. So the question is about the common rule and whether how that applies to federally funded versus non-federally funded research, and when research is not federally funded, what are the implications as far as essentially IRB review and those sorts of issues. There's a couple of things I think to note is that institutions that conduct research have the option to do what we call check the box. And that means that in order for institutions to do federally funded research with human subjects, they file what's called a federal-wide assurance with the OHRP. And as part of the federal-wide assurance, institutions decide whether or not to check the box, which means they make a decision about whether they are going to apply the common rule, which is, by the way, 45 CFR 46. It's often referred to as the common rule. They decide whether or not to apply the common rule to only federally funded research or to all research. And historically, I think a lot of institutions have decided to apply the common rule to all research. It's an effort to ensure that research is conducted ethically. No school wants to find that one of their faculty have conducted research that is potentially unethical, but it's not federally funded, so it didn't have to comply with the federal regulations, but it was unethical, and so what are the implications for the institution for that? So I think that's been a major reason that institutions have decided to require their researchers to comply with all of the regulations governing research with human subjects. Now, as part of the advance notice of proposed rulemaking that was published back in July, there has been a question raised as far as whether the common rule should, by regulation, apply to all research, regardless of funding source. And I don't know what direction that's really going to go in. On the one hand, I think from an institutional liability perspective, there's a lot of merit in not opening oneself up to audits unnecessarily by the government. If research isn't regulated because you haven't checked the box, because you haven't made the decision to apply the regulations to all research, then it's not subject to federal oversight, and so that's potentially easier. But on the other hand, I think it does a lot to encourage ethical research to apply it across the board. And I think, I don't know, I mean, it's interesting. The Presidential Commission on Bioethics recently said that they think that the current set of regulations actually is adequate to protect against studies like the one that was conducted in Tuskegee, Alabama. So, in light of the fact that there are going to probably be some changes to the regulations, but it's unclear, how much they're really going to change. I don't know how much that issue will change with it. I'm torn because I can understand it from the institution's perspective, but I think that there is a potential risk if institutions choose not to apply it. But they're not forced to now, and we haven't had a repeat of Tuskegee, so.
I would say also that many historians don't love this proposal at all. I can't say every single one in the U.S. feels that way, but they feel in many cases sort of misunderstood anyway, especially if they have to go to an IRB and like, oh, this is just going to make it all worse.
Well, and I think especially in light of the
Yeah.
fact that it was really designed to protect against participants in biomedical research, and it kind of expanded to apply across the board, and there are varying schools of thought as far as whether oral histories are subject to the regulations. Is that really human subjects research?
Yeah, and I think most people are assuming that it is at this point, at least in my world, but so grudgingly in some cases, yeah.